Hey Charles, how's it going this morning?
Good. How you doing, James?
I am good and I am ready to talk about office actions and trademarks.
Let's do it.
So, obviously, this is something we deal with a lot, but for some folks who are out there, they may have never heard of what an office action is. So, kind of what's your summary of what is a trademark office action?
Trademark office action is basically when a trademark examiner gets your application, looks at it, and has something to say about it. Usually, we see that in some form of provisional refusal. So, we will see an office action issued against a mark. We take a look at it and we see what the various issues are cited against the mark. And like I said, most of the time it's because there's some preliminary issue that the examiner is asking for further documentation, further work from the attorney or the applicant in order to get the application through.
Yeah, and it's funny because sometimes an office action can be many hours of work, and sometimes it's a 5-minute phone call, right? I know that
Yeah.
sometimes we'll get the call from the trademark office, and they say, "Hey, we have an office action." You get an email, "There's an office action," and you look, and it just says, "I need you to change this one word here."
Yeah.
And they do
Yeah.
that thing called an examiner's amendment, right? Well, we can just call the examiner and say, "Hey, examiner, we agree with you. Add a comma in here or delete this word here." And with that, the office action is resolved and it can go forward. But obviously, there's office actions that are more involved. So, what are some more complicated issues that come up where we get that initial office action from the trademark office?
Yeah, if we're not looking at an initial examiner's amendment, which obviously we prefer, it's really nice to be able to kind of get those issues through pretty quickly. The more common issues that we see that can't be uh, remedied just by a quick examiner's amendment are likelihood of confusion refusals. That's by far the most prominent refusal we see. And basically, that means the trademark that you're filing is somewhat confusing and similar to another trademark that's already been out there, whether that's an application or a registration. The policy being, we don't want other marks being registered that might be too similar and filed under a same or similar class of goods and services because we don't want the public to be confused as to the source of these various different brands. So if you're filing for uh, Creedon water bottles, and there's already a Credo water bottles application or registration
Darn.
out there. I know you're not going to be able to get it. So really, we're just kind of what something that we do to kind of prevent that for our clients who come to us at the very beginning stages before they file any kind of trademark is we look for those sort of things. We do a full and thorough clearance search on our various systems that we have available to us to make sure, hey, you're probably not going to get this exact mark. Let's think about adding something a little bit more distinctive that's going to set it apart from these other marks that are out there so that we can head off these issues before they happen.
Yeah, and those clearance searches, that takes a fair amount of work, but that's like you said, us looking at not just trademarks that have been filed before, right? Not just, hey, is there a Credo water bottle application in the trademark office,
Mhm.
but also is there a Credo water bottle company out of Arkansas that we can find, or is there a Credo bottle, Facebook profile where they're using it? And at the very least, we can identify that there might be something out there that could cause confusion. So obviously, likelihood of confusion, that's a big one in the trademark office,
Mhm.
it seems like that's probably a good half of the office actions that we get.
Yeah.
Um, but then there's other ones that come up that are a little bit more funky. So, for example, there's disclaimers, right? You get an office action that says you've got to do a disclaimer here. What is that all about?
Yeah, a disclaimer is usually for material that is descriptive or material that is not inherently distinctive. So, what I mean by that is if we were to file for Creedon water bottles would likely need to be disclaimed because that is going to be descriptive of the product that we're selling. So basically, the policy behind that is we don't want any companies filing for descriptive subject matter that may be preventing other companies from using that descriptive subject matter to describe their own product. So if I apply for Wallace water bottles, I don't need to get a refusal because Creedon water bottles already exists. So what a disclaimer does is it just makes sure that federal protection isn't bestowed on those descriptive elements. It doesn't change the mark in any way, doesn't take anything away from the mark. The mark still looks the same. It's still the exact same on the registry. We're just not claiming protection in the disclaimed subject matter. And
Yeah.
usually disclaimers are pretty easy to get through, right? I mean, many times an examiner's amendment can satisfy a disclaimer, but we also see disclaimers kind of tacked on to some of these other refusals, like likelihood of confusion, and then also just if we have a mere descriptiveness refusal. If we apply for simply water bottles, that can be a mere descriptiveness refusal where we're probably not going to get that trademark because the trademark in its entirety is descriptive. So those are kind of the three major refusals that we see.
So we have our likelihood of confusion. That's the
Mhm.
big one. We have our disclaimers.
Mhm.
And then, of course, we get into all sorts of funky other office actions, right? The more complicated ones.
Yeah.
Obviously, we've done a fair amount of cannabis trademark
Oh, yeah.
applications, and we deal with these very lengthy rejections from the trademark office that say, look, your mark could be okay. There's no likelihood of confusion. There's no one else out there creating, Creedon CBD, but and there's no need for a disclaimer. Maybe your mark is just Creedon, and that's fine. But they say, well, but what about FDA regulations? What about the Controlled Substances Act? We want
Yeah.
you to reply to these specific questions about what's the THC content of your product? Where is it manufactured? How long have you been offering it? What date was it first put into the marketplace? So there's office actions that can be much, much longer. How do you figure out when a client comes to you, whether it's going to be a 1 hour or a 3 hour or a many hour office action?
Yeah, I do most of the office actions at the firm right now. And one of the main things I look at is what is the complexity of the office action? Because
Hmm.
each time, just kind of learning about the issues, running them down, I always contact the examiner to try and see if I can expedite this for the client, making it more, um, you know, uh, more doable, a little bit more economical for the client. It really comes down to the various issues. So if we're getting one of those FDA refusals, obviously we have to be very, very careful about what we're putting on the record because we want to make sure we're saying everything right, we're doing
Mhm.
everything ethically, and so those take a little bit more time to make sure that the client understands what we're necessarily giving up if we have to do that. So usually, if we're getting a likelihood of confusion refusal, that's probably kind of in our tier two or tier three, being kind of the more difficult, more in-depth refusals. Something like a disclaimer or changing a market description or changing the description of goods or services that are covered by a mark. Those can be pretty easily done. Usually, that's in tier one that we do at our most cost effective refusals. But it's really kind of uh, we need to look at these on a basis. Just, once something is given to us, it's really not a look at it and immediately say, yeah, tier one, tier two, tier three. It's really important for us to go ahead and call the client, run it down with them, run it down with the examiner, and then we can give the client a good idea of what we can do in terms of cost.
And of course, once that office action comes out, time is ticking for us to get a response in,
Sure.
right? So
Sure.
if we get an office action, the normal response timeline is 6 months. And it will
Mhm.
say, as of Jan 1, here's your office action. You have 6 months to respond.
Yep.
To get a full response in, what happens if we miss that response date? If I don't want to deal with it, or I just don't want to think about it, or I just forget about it, what happens when those 6 months come and go and I haven't responded to the office action?
Well, we don't forget about it, but
That's true.
yeah,
That's
but
true.
there are times when a client comes to us and says, "Hey, this needed to be filed last week. What do I do?" That's fine. I mean, this does happen a lot as long as the client let the thing lapse in good faith and just kind of accidentally missed the deadline. That's not going to necessarily completely terminate or cancel your mark. Basically, what the USPTO does is they consider the trademark the day after it's supposed to be filed. They consider it abandoned, and so what you're going to need to file is a petition to revive that abandoned application. And that's easy enough to do. It's basically just a declaration saying, "Hey, look, I accidentally let this thing lapse. I missed the deadline. Please let this trademark be revived." And that's a $100 government fee. We don't charge anything for doing that, so we just kind of tack that on because we want to make sure the client knows, you're well handled. You got to pay the government fees, but we're not gonna charge you for our time in filing this petition.
Sure.
And that's easy enough to do. And so what the timeline looks like, though, I'm not going to say if you don't file anything in response, you're going to be fine in every circumstance. You have about 2.5 to maybe 3 months from the date that you're actually supposed to file. And what you're going to look for, though, is your actual abandonment that is issued by the USPTO. So once they issue your abandonment, you've got 2 months to file your petition to revive. And like I said, usually it's probably about half a month to a month after the deadline when those things issue. So to answer your question, James, I mean, this happens all the time to clients. I mean, we have lots of clients who come to us with responses that they should have filed, and we just say, not a problem. We can get this thing revived. No issue. We're not going to charge you for our time. We just want to make sure you get the mark. I mean, that's the most important thing,
Now, of course, the flip side of that, of course, is if it goes abandoned and you don't file that document in time, then it means your application is truly abandoned. And so sometimes someone comes and they say, this office action response was due 6 months ago or however long ago. And at that point, your application is truly abandoned, meaning that you lost out on the initial money you paid to file the application.
That's right.
And you lost out on that priority date, on being first in line with that application being filed. So if we have to file a brand new application, there's a whole other government filing fee. We're restarting the clock on when your filing date is. So, abandoned means abandoned. It's not something that if you've already spent the time and money to get the thing going, let's try to keep it in the process.
Right.
So let's say you file a response to the office action, and for whatever reason, and we know that for complicated ones, this can certainly happen, the examiner comes back and says, yes, but you've answered most of my questions, but you haven't quite answered this one. Or, hey, in the intervening 4 months, I actually thought about another thing. So thank you for responding to your office action, but now I got a new thing I want you to do. That's the same 6-month deadline, right? But what happens if you respond again and they say, look, you still can't overcome this? What happens next?
Yeah, it's difficult because you do get 2 bites at the apple. So that is a good thing for applicants to know. Even if they do get a refusal and a response is filed, even if that isn't successful, you get what's called a final office action. At that point, you can file another response. It's technically called a request for reconsideration, but it's another response that you get. If the examiner brings a different issue that they should have caught before, which happens more often than you would think, it's not a final refusal. It just becomes another office action. So basically your apple becomes whole. You get to take another 2 bites. But in the event that your request for reconsideration is not accepted, the refusal does become final, but you can actually appeal that to the Trademark Trial and Appeal Board. And basically that becomes an administrative proceeding as between the applicant and the examiner. And so you're basically put in front of a board of examiners who are going to look at this refusal. They're going to look at all the responses, and they're going to kind of take your argument and the examiner's argument and say, should this application actually make it through to registration? So even if you are fully refused, you still have that available to you.
And so hopefully at that point, you're good to go. But obviously, no one wants to go that far down the road. And that's why we try to identify all these issues ahead of time with our clearance searches and such. But there is one other funky aspect to office actions that I just wanted to mention today, which is the suspension, the infamous suspension, right? So why don't we share a little bit about what it means when you get a suspension notice from the trademark office?
Sure. So we don't like suspensions at all. They, that's why we do such a thorough clearance search at the beginning, because we don't want to get a refusal, but we really don't want to get a suspension, because oftentimes what is waiting at the end of the suspension is a refusal. So what this means is, if there is a pending trademark application, let's say Credo water bottles is pending, but it's not a registered trademark yet, and we apply for Creedon water bottles a day later, let's say, we will get what's called a suspension, which means that our application examination is going to be suspended pending the examination of the Credo water bottles. So if that applicant ends up abandoning their trademark application, or if they don't end up getting their trademark application for any reason, then our mark is going to be fine. It'll be lifted from suspension and it'll go through examination. But if Credo water bottles ends up registering, then what your suspension will say is then the examiner will see if they're going to issue a refusal against your mark based on this previously filed marks registration. I
Yep.
have always seen those actually end up in an office action refusal. I mean, that's typically what happens. And the reason we really don't like suspensions is they can last a very long time,
Yeah, you get frozen in time, right?
a
Because
really long time.
if you get a suspend like your example, if Credo was filed yesterday and we filed for Credon today, we are as in suspension until that Credo application goes all the way through the process and gets a final determination.
Hmm.
So if they get an office action and then another office action, it can be a year and a half before we even find out what's going on with our suspended application.
That's
And
right.
then the other frustrating thing, of course, is that on the examiner side, a suspension, the status of a suspension gets looked at every 6 months.
Yeah,
So there's a world where you get a suspension, the Credo mark is resolved, but then your application just sits there until the examiner looks at it again. And unfortunately, there's very few options to speed up that suspension process. You can do your best to send a note, but there's no official mechanism to say, look, the suspended issue is over. Look at my application now. Sometimes you're at the whims of the trademark office.
that's right. And sometimes it becomes even more frustrating when, let's say, the Credo water bottles is filed as what's called a an intent to use application. And so if they are filing as an intent to use application without getting too much into it, that basically means they're not getting their registration until they amend it to in use. And that can last up to 3 years. So if the entire examination and publication takes roughly 1 year, they could do another 3 years after that. And so you could be looking at 4.5 years. And in some circumstances, a pending trademark can itself be suspended. So you can find yourself in this chain of suspensions that are all kind of waiting on
Yeah.
one another. So it
Yeah.
becomes a huge mess. Again, the reason why clearance searches before we even file anything is super important.
And also the reason why, from the moment we do a clearance search to the moment we file, we want to keep as short as possible.
Oh, yeah.
You don't want that rare circumstance of you finish your clearance search on April 1st, and then you wait until May 1st after you file the application. And in those intervening 30 days, something pops up.
That's
When
right.
we do our search, normally an application in the trademark office will show up on the official records within 1 or 2 business days.
Yeah,
So we can feel pretty confident in our search, but every time we wait, it just increases the risk of an office action. So,
that's right. That's right.
well, obviously, office actions, it's a little bit complicated from the point of view if you haven't done it much. We, of course, have done years of these office actions, and
Oh, yeah.
so I think we have a better sense of it. But obviously, questions come up, and so if you're watching this video and you're dealing with an office action or you have questions about it, you can leave a comment. You can email Charles or email me or come visit our site, look at our blogs that tell you more about it.
Mhm.
And at the end of the day, we're happy to help you because our firm's all about building and protecting great brands, and this is a key part of doing it. So, Charles, I appreciate your time this morning. I know it is a Friday, and we all want to go and enjoy our weekends. So, any big plans for the weekends?
Yeah, actually, I'm competing in the Scottish Highland Games of North Texas
Oh,
tomorrow morning. So, yeah, after work, I'm taking my son to the store. We're going to grab some steak so I can have my annual steak and egg breakfast beforehand before I go and bake in the sun all day, throwing heavy things.
well, hydrate, stretch out, and don't hurt yourself because we're going to need you for office actions on Monday.
Oh, I know. Oh, I know. We've got a few.
Well, very good. Well, good luck with the Highland Games, and
Thanks.
thanks for sharing your info on this. And everyone out there, we'll see you next time. Take
All
care.
right. Take care, everybody. Bye bye.